Good morning, Mr. Spring.
Madam Chief Justice, and may it please the Court, Christopher Spring, Special Assistant District Attorney, on behalf of the District Attorney for the Northern District. I am joined this morning by Assistant District Attorney Loretta Lilios. The case before the Court illustrates the unconstitutionality of the accord and satisfaction statute. The District Attorney was precluded from offering evidence on an otherwise valid complaint after the judge made a discretionary decision that the prosecution was not warranted. The judge's decision and the statute that authorized that decision is in conflict with Article 30, the Separation of Powers Doctrine of the Massachusetts Constitution, and for that reason this Court should rule that the accord and satisfaction statute is unconstitutional. Discretionary dismissal of a complaint by the judicial branch has the same effect as a nolle pros, and as recently as 2003 in Commonwealth v. Cheney, the Court held that in the context of criminal prosecutions, the executive power affords prosecutors wide discretion in deciding whether to prosecute a particular defendant, and that includes whether or not to issue a nolle pros and end the case prior to a verdict, finding, or a plea.
Isn't this authorized by the legislature?
Your Honor, it is authorized by the legislature. However, when a legislative act is in direct contradiction to a constitutional provision, that legislative act must fail.
Well, how does this differ, Mr. Spring, from civil disposition of certain traffic offenses, for example?
Your Honor, in those cases, the legislature specifically authorized the court to make those civil infractions. So in this case, if the legislature, for example, said that in the cases of domestic assault and batteries, the judge would have the authority to reduce that to a civil infraction, then perhaps that would pass constitutional.
Well, haven't they essentially done that? In Section 55, they said that in misdemeanors, which assault and battery is a misdemeanor, if the victim is in agreement, an accord and satisfaction is sufficient.
This Court, however, Your Honor, has always looked at pretrial judicial dismissal with no conditions, with no supervision, as an effective nolle pros. And once the Court recognizes that that is an effective nolle pros, the Court has recognized, dating back to 1806, that only the executive branch of government is authorized to issue that nolle pros.
But this differs from a nolle pros. The Court has to open in public, review it, and determine that it is a permissible disposition. It isn't like a nolle pros.
Well, the Court, pursuant to the statute, is making a discretionary decision that prosecution...
The Court's not making the discretionary decision. The legislature has said you shall do this. In other words, if there's an accord and satisfaction, what you have to do is look to see whether, for example, it's voluntary, very important to domestic abuse cases. I mean, there are a number of other steps, but in essence, the discretionary part really goes to making sure that the statute is being complied with, as opposed to, in other words, this is not the judge, being in touch with the victim saying, now how about this? And this is the victim coming forward.
That's true, Your Honor, but the judge does have discretion pursuant to the statute to either accept that accord and satisfaction or not.
Yes, and the statute then provides, and there's, some judicial gloss on it as to what the judge making sure that the statute is being complied with.
And in affording that power to the judicial branch, the power to dismiss a case over the objection of the Commonwealth, the legislature was transferring what has always been historically an executive function, whether or not to prosecute a case, the discretion to decide whether or not prosecution is worthwhile, and the legislature has unlawfully transferred that power to the judicial branch.
You cite Rotunda, but in Rotunda, didn't we say that we had that there'd be a violation except so far as authorized by statute? And this is authorized by statute. You agree with that?
I do agree with that, Your Honor.
And your claim is that the statute is unconstitutional.
That's correct. The question left open in Rotunda is what happens when the legislature enacts a statute that is inconsistent with the Constitution. And I submit that in that case, certainly the statute cannot be enforced if the Constitution would be violated by its enforcement. And that is what's happening with the accord and satisfaction statute.
How old is the precedent? I mean, accord and satisfaction precedent, not just this statute, but its predecessor statutes. Go back how far?
It goes back several hundred years, Your Honor.
Does it go back even older than the Constitution?
It does, Your Honor. It does go back further than the Constitution, but the statute has never been challenged. There's never been a constitutional challenge to the statute, and I suspect the reason for that is because the executive...
If you're going to hypothecate about several hundred years of reasons for not challenging it, that may be a problem.
Yes, Your Honor.
You make the argument at pages 14 to 15, I think, of your brief, that the dispositional alternative must also offer some substantive component. What authority do you have for that proposition?
Your Honor, the authority is the precedent of this court stating that a pretrial judicial dismissal is the effective equivalent as a null pros, and that is distinguished in the Piles case, which authorized the Quaff statute and said that that passed constitutional muster. In that case, the Quaff statute was upheld, as were several other cases that were mentioned as dispositional alternatives. And in each and every one of those cases, there are consequences that go along with the ultimate dismissal. It's a conditional dismissal so that the defendant, for example, is under the supervision of the probation department. The defendant oftentimes has to complete educational programs. There is some condition that the defendant has to satisfy before the case is dismissed. It appears that the accord and satisfaction statute is the only statute where the case can be outright dismissed, unconditional, with no supervision, no educational programs. The defendant does not have to do anything after the case is dismissed. And that is what makes the accord and satisfaction statute different from other...
He does have to satisfy his victim.
That's correct, Your Honor, but that's a private agreement with the victim. And I think it's important to distinguish between what the judicial branch is ordering by way of being on probation or under the supervision of a probation department and a private agreement with a victim that leads to dismissal. And this is where the constitutional issue collides with this court's opinion in Commonwealth versus Rotunda. And the language of Rotunda, I submit, is absolutely applicable to this case. In describing the bedrock principle of American justice, this court held that private payments exchanged for releases from criminal responsibility erode, if not completely erase, the demarcation between the criminal and civil systems of justice. In the Rotunda case, the court essentially manufactured an accord and satisfaction. The court said to the defendant, if you pay $5,000 to the victim, then this case will be continued without a finding. And this court noted that the victim was selected, the $5,000 payment to the victim was selected without regard to any fact other than whether the payment might, quote, satisfy the victim. And that is exactly what the accord and satisfaction statute provides for.
Well, as you know, the Attorney General takes a slightly different point of view and says that this is not a private, it's a publicly approved, judicially sanctioned agreement. And in any event, one of the problems, it seemed to me, in Rotunda, was the judge reaching out and saying to the victim, you know, if you will, would you be satisfied if the following applied? And I think that's a very different set of circumstances.
I think it's, in fact, even more problematic in this case, where you're allowing a victim who is not even a party to the litigation to make a determination as to whether or not the executive branch can pursue a prosecution.
Well, there are other instances, and as you know, that this is a dispute between a husband and a wife, and I understand that there are concerns about whether or not agreements may be voluntary, and that, as I understand it, the district attorney, you have not challenged that this was a voluntary agreement. You don't say that the judge's finding that it was voluntary is clearly erroneous, correct?
The district attorney is not challenging that it was voluntary, but I think that in the framework of domestic violence cases, and this is a perfect example, you often have a situation where the district attorney is in a position to advocate on behalf of a victim who is not in a position.
I understand that, but it makes a difference. Not every domestic dispute is one of a pattern of abuse, a pattern of violence, and that's why it was significant to me that the district attorney did not challenge that this particular agreement was voluntary.
That's true, Your Honor, but oftentimes the district attorney will not know whether or not there is a pattern of abuse. This could be the first time that the defendant is in court. That doesn't necessarily mean that this is the first.
Of course not, but I think judges are in a position, as with respect to lots of things, to make searching inquiries to whether or not it's voluntary. If there's anything that suggests to the judge that it isn't voluntary, it might not be acceptable.
I think that's true, Your Honor, but again, I think that the judge is not in the best position to determine whether or not there's a pattern of abuse, whether or not this is in fact voluntary. based on the situation that domestic violence victims find themselves in, that they're oftentimes living with the defendant, oftentimes they have children with the defendant. They're not in a position, when you're asking who is the best person to decide whether or not this prosecution is going to proceed, you're asking somebody who oftentimes has a financial interest in making sure that the defendant does not continue in the criminal justice system. That the defendant...
Mr. Spring, what do other jurisdictions do? Do other states have accord and satisfaction?
Your Honor, I'm afraid I don't know the answer to that.
All right.
Going back, Your Honors, to the Rotunda case, again, in Rotunda, when this court said that, and the court said that the $5,000 payment to the victim was selected without regard to any fact other than whether or not the victim was satisfied, I submit that that is directly on point when talking about...
But the Rotunda made it very clear that this had not been presented to the court as an accord and satisfaction.
That's correct, Your Honor, but when you look at the functional way that this happened, and this court did find that the payment was selected for no other reason other than that it satisfied the victim.
But there's a big difference. In Rotunda, was there any statute that authorized what the judge did?
There was not, Your Honor.
Okay, well, here there is. That's a basic difference between the two.
Was that an assault and battery on a police officer?
On a traffic officer, yes, Your Honor. And it was the
ABDW?
The defendant was charged, I believe, with threats and with a civil rights violation. And again, Your Honor, going back to the fact that there is, in fact, a statute in this case, again, the question that this court will have to answer is whether or not that statute is constitutional. I submit that the legislature improperly transferred an executive function to the legislative branch. Whether or not to pursue a case, whether or not to continue with a prosecution, whether or not to end a case prior to the case by way of a null pros has always been an executive function. And in saying that the judicial branch can exercise that executive function, the legislature enacted an unconstitutional statute.
Now, the legislature surely can enact dispositions as it sees appropriate, right?
Yes, Your Honor.
And dismissal is a disposition.
Your Honor, I submit that given the language and the history of this court, it is not a disposition. This court has had the opportunity time and time again to define pretrial judicial dismissal as a disposition, and each and every time this court has defined pretrial judicial dismissal over the objection of the Commonwealth as the effective equivalent of a null pros. And I think that when you look at the language of this court, the language that this court has historically used to describe that type of conduct by a judge, you can come to no other conclusion that this was in fact...
Well, let's assume the legislature enacted a misdemeanor malicious destruction statute that in essence said on a first offense the case shall be dismissed upon the certification of the victim that they've received restitution.
I think if the legislature is creating a criminal act, so the legislator is defining a certain act that is criminal, the legislature is giving the district attorney, based on the district attorney's inherent power to prosecute crime, the obligation to prosecute that. And I think it would be unlawful for the legislature to say this certain act is criminal, however, the district attorney does not have the power to prosecute that crime.
So your objection here is not to the fact that the court has discretion to dismiss or not, but the fact that the legislature has provided for dismissal.
That's correct. That's correct. The fact that the legislature has provided an opportunity for the judicial branch to dismiss a case over the Commonwealth's objection, I submit, is unconstitutional.
So even if the legislature required a dismissal in certain circumstances, such as first offense, malicious destruction, victim certified, restitution has been paid, that as well would violate the separation of powers.
I believe it would, Your Honor. I believe...
Well, we have a statute, that, I think, that says first offense marijuana. Doesn't that require dismissal?
After a program, and that was one of the statutes that was cited.
So how does that work? Does it have to be with the Commonwealth's consent? Does it have to be on a continuous without a finding?
It does not, and as with a quaff, the judicial branch has the opportunity to enter that disposition over the objection of the Commonwealth, and in Piles, when the court indicated that that wasn't an appropriate dispositional alternative, that was one of the acts that was cited, and again, that requires the defendant to complete a program and a period of probation before the case is dismissed. So it is a dispositional alternative in the sense that it's a conditional dismissal. This statute provides for an unconditional dismissal, and that is what distinguishes it from the acts in piles, the Quaff statute and the other acts that are cited in piles.
Mr. Spring, I don't want to single you out because there are lots of lawyers here, but I have a brief from the District Attorney of Middlesex, which is not in compliance with the rules of appellate procedure. It has no table of contents. It has no citations to any of the legal authorities. It doesn't attach the statutes. It doesn't attach the judgment appealed from. I would ask the District Attorney to make sure that all briefs are in compliance with the rules of appellate procedure.
I'll do that. Thank you, Your Honor. I see that my time has expired. In closing, I would ask the court to strike down the accord and satisfaction statute in that it is in violation of Article 30 of the Massachusetts Constitution and it violates public policy. And I thank the court very much for its time.
Thank you, Mr. Spring. Mr. Monahan.
Good morning. My name is Joseph Monahan. My office is in Cambridge, and I represented Victor Guzman in this case. The court asked a question about the voluntariness and whether or not there was an inquiry at the court hearing. By way of history, if I could recite the facts a bit, on October 18th of 2003, the Arlington police responded to the home of the Guzmans in response to the complaint of a woman yelling. The police arrived at the location, did not observe any woman yelling, knocked on the door. My client, Victor Guzman, answered the door. The police officer said he wanted to do a well-being check, asked my client if he had an argument with his wife. My client said he did, and that he would resolve it in the house. He allowed the officer in to do a well-being check. Mrs. Guzman, Dr. Jane Yang, it's his wife, was upstairs in her bedroom talking on the cell phone, not crying. The police officer walked up the stairs, opened the door, walked into Dr. Yang's bedroom. She became hysterical, demanding that he leave. She said, "I had an argument with my husband. I don't want police involvement, and I'm fine." The officer notices a bruise over her left eye, at which point he then asks her about it. She refuses to speak to him and orders him out of the house. Officer goes down, pursuant to his police authorities, conducts an investigation, has a conversation with my client, who says, according to the officer, that my client admitted to hitting her. Dr. Yang then came down and said, "Yes, we had an argument over the Red Sox game. I wanted to talk to my husband about a family problem. He wanted to watch the Red Sox game. I turned the TV off. He turned it on, and we went back and forth with that for about 5 minutes, at which point, this is late in the year, it was during the playoff series, Mr. Guzman then pushed her out of the way, and at which point she said he hit her. She denies that. But in any event, my client is arrested. He's taken to the Arlington police station. He's held overnight and released the following day.
All this is in the record, I assume.
This is all in the record. And
could I ask you to jump forward, though? I mean, when she signs this thing saying that she has received, quote, satisfaction, does the record indicate what she received in the way of satisfaction? I mean, I must say, from what I've seen so far, it sounds like she didn't receive satisfaction. She simply decided that she did not want to testify and did not want the case to proceed.
As part of the discovery process, the DA provided to defense counsel an affidavit that it's called a victim witness statement, but signed under oath, signed by Dr. Yang, at which point she said, number one, I was never intentionally struck by him, but number two, this case is continuing to drive a wedge in my marital relationship.
What did she say she had received by way of satisfaction?
She didn't acknowledge that she received any satisfaction, except that if the case were dismissed, that she would be able to live in peace and harmony with her husband, and that this case is driving a wedge in that family relationship.
Is there anything in the history of this legislation or in our cases indicating whether an exchange of money is contemplated by the statute, an exchange of money between the defendant and the complainant? Even though the statute does talk about satisfaction, there is nothing in the history of the cases that I read, going back to Jones v. Rice, which is 1835, which is the first case on accord and satisfaction, that says that money has to be paid.
But it doesn't have to be money. But I mean, I'm troubled by. I mean, it seems to me when we're looking at the, one way of looking at the constitutionality of the statute would be to say the legislature has said that if the defendant has supplied satisfaction, then a defendant has at least done something restitution was one of the examples given here. The defendant has had to do something to make up for, if you will, the crime that he has committed. It might not necessarily be money, but it does. I have some difficulty understanding how received satisfaction simply equates with the victim saying, I haven't received anything, but I just don't want this case to go forward.
There is nothing in this record that indicates that the defendant received anything.
That the victim received anything.
I'm sorry, that the victim received anything. The affidavit that was signed by the victim was considered by the judge. He then put the victim on the witness stand and made an inquiry of her as to whether or not her statement was voluntary. He conducted an extensive interview of her, and he was convinced, according to the findings he made, that the statement was voluntary.
Right, but what's the satisfaction? What was the satisfaction that she received?
There is no satisfaction here other than to have the case dismissed and be able to live in harmony with her husband.
That's not an issue in the case, is it? Isn't the DA hasn't attacked it on the basis that there is no satisfaction, no money paid. He's just arguing the thing is unconstitutional.
That's correct. The DA is not making that argument. I didn't understand that to be an issue here, but in the cases that I've read, going back from the 1835 cases right up to Commonwealth versus Piles, which is a 1993 case, I believe, talked about the legislator's broad authority to enact.
Maybe in the next case, if the DA raises that issue, we can get down to deciding whether you need to pay something or do some affirmative act other than this will, sort of repair a little bit of a split in my marriage. That's the next case, is it not? Perhaps, but
that's not this case, I don't think, but maybe if it has to be, it will be.
In this case, the court made some inquiry into the voluntariness of the accord and satisfaction. What else? The court made some inquiry. So you, as you said, put the complainant on the stand, questioned her about the voluntariness of her statement and her having received satisfaction, whatever you want to call it. What else did the court do here that we should require in future cases?
The court looked at the affidavit that was filed by her, asked her whether or not that was in fact voluntary. She said it was, and that's what she wanted in this particular case. The court then reviewed the police report, read the police report, and then heard arguments from counsel, at which point the DA indicated they were going to contest the constitutionality of the statute. We briefed it. So
the court read the police report. Why? To determine this sort of the level of seriousness of the offense, or what was the point, do you think?
The DA offered it at this hearing without objection from myself as defense counsel, and we in fact contested some of the facts in the police report, but the judge made a decision that 276-55 allows him to do this because it's a creature of the statute. But the judge did do, well knowing that the constitutionality of this case was going to be challenged, he basically looked at the strictures as outlined by this court in Brandano and imposed those strictures to this accord and satisfaction statute. In other words, he looked at the affidavits, he conducted a hearing, and then he issued written findings so that a reviewing court, when they were trying to analyze whether or not there was abuse of discretion, has a record from which to make that determination.
So would you suggest, there's nothing in the statute that requires that. Are there any cases that require that in an accord and satisfaction case?
There are no cases that require that in a accord and satisfaction case. My concern is that because this does involve a separation of powers, a constitutional issue, that strict compliance with, I think, the strictures as mandated by Brandano would satisfy any type of separation of powers argument. Brandano is analogous, but it's right on the point in terms of a reviewing court having an opportunity to review the basis of the decision of the trial court. In the earlier cases, the court was concerned about private agreements between two people to resolve a public dispute. And it's those private agreements that we have right here in the accord and satisfaction statute. And the problem, as I see it, with this statute is the fact that, as I mentioned earlier, there should be some writing, there should be some basis, and we have it in this case to justify the judge's action in this case. The court, in the Piles case, if I could read, and I think this is important, cites the Weems versus the United States case and says that the function of the legislature is primary exercise is afforded by the presumption of right and legality. It's not to be interfered with lightly, nor by judicial conception of their wisdom or propriety. This case, this accord and satisfaction case, is a statute. It involves a resolution of minor matters in the district court, assault and battery and other misdemeanors. It has a place in the district court. A district court can handle this as long as the district court is in a position where they make findings of fact so that this court or any reviewing court has a basis to make a determination whether in fact there was an abuse of discretion. I suggest to the court respectfully that that bypasses any constitutional concerns about an Article 30 violation.
Thank you. Mr. Monahan. Mr. Smuller.
Good morning, Chief Justice Marshall. May it please the Court, Daniel Smullo on behalf of the Attorney General. The question before this Court is essentially this: whether Chapter 276, Section 55 falls within the legislature's ability and province to enact criminal law and define criminal procedure, or whether it's an improper intrusion into the function of the executive branch and therefore violation of Article 30. It's the Attorney General's position that it falls into the former category. The statute must be publicly approved, judicially sanctioned. There must be some civil component to the criminal statute. That is, it must also be a civil violation in addition to a criminal violation. It must also be a misdemeanor. All of these requirements are careful strictures to ensure that Article 30 is not violated. This is a very different situation from Commonwealth versus Cheney, where the judge dismissed the criminal violation, essentially for the reason that the judge found that it was in the interest of public justice to do so. Here, again, all of these requirements that are part of the statute and have been part of the statute for several hundreds of years all show that, in fact, this is a valid, lawful disposition and that the legislature, acting well within its authority, is defining criminal conduct and essentially criminal procedure, saying in these narrow circumstances, the judge may judicially approve this publicly entered into accord and satisfaction and therefore dismiss the case.
Is it your view that the court ought to go through some form of Brandano procedure and make specific findings that the dismissal is in the interest of public justice or
I think the statute does. Excuse me, Your Honor.
The statute just says in its discretion.
I think that's correct. I do think that there should be some sort of judicial finding. The reason for that is this: the statute also calls for the judge to act within his or her discretion. Now, under Chapter 278, Section 28E, the district attorney could then challenge the finding and say that this was in fact an abuse of discretion.
I assume, for example, if there had been multiple prior convictions for assaults by the defendant upon his spouse or others, that might be a basis for the district attorney to say this is a totally inappropriate exercise of discretion.
I'd assume that would be a very good basis and likely would constitute an abuse of discretion. And were a district court judge to enter such a finding, the district attorney could then challenge that and appeal it as an abuse of discretion.
Mr. Smuller, I know that Attorney General hasn't taken a position, at least in his brief here, and you may not wish to address this, but the Committee for Public Counsel Services quite specifically asks us to construe the statute to the extent that we have to, so as not to require payment of money. That is to say, the Committee for Public Counsel Service often represents indigent people. Does the Attorney General have any position with respect to what accord and satisfaction means? As opposed to, for example, what the judge did here. The judge said, after going through the voluntariness and so on and so forth, what the judge, the the sort of linchpin here was that the accord and satisfaction, that he or she would accept the accord and satisfaction, quote, as a fair and just means for resolving the pending case. I mean, I take it that that's, what the judge was trying to do was to explain the basis, but...
It would have been perhaps helpful here had satisfaction been defined more specifically. Attorney General doesn't necessarily believe that it must inherently be a payment of money.
Well, can it be an apology? Can the victim in the case say, I received an apology and I'm satisfied with that?
So it's theoretically possible. Another example might be a stay away. Two neighbors get into a dispute. There are criminal charges that are brought, and one neighbor says, stay away from me at all times, and therefore that would be
well, that's true,
satisfaction.
but it is also the case, and I think there's an excerpt from Justice Nolan's thing, that people do get into disputes, and then maybe they sit down and talk, and maybe, you take out criminal trespass because you keep driving, too close to my fence, and, he says, well, look, I realize you really do take this seriously, or after the criminal complaint is taken out, the neighbor observes that he never drives close to the fence and says, look, that's good enough for me. In other words,
They've settled their differences in some
they've
fashion.
settled their differences, but to what extent do they have, I received an apology, that may just exacerbate the problem of the neighbor next door. The neighbor says, look, I'm not going anywhere near your fence. I'm not going to apologize. I don't think I did anything wrong, but I'm not going anywhere near your fence again. And it's, do we have any inkling from the prior cases as to what constitutes accord and satisfaction? Other than we settled our differences, I don't wish to pursue this.
I think there may be a broad universe as to what satisfaction means, and it would be answered on a case-by-case basis, which is why it's up to the district court judge to make that determination as to whether the party's definition of satisfaction is in fact sufficient.
Is it, well, I hear time's up. Is it your view that the statute is constitutional even if there has been nothing, not even so much as an apology or any other change, nothing afforded to the victim whatsoever?
In that case, Justice Sussman, the statute is constitutional, but the finding that it was sufficient would likely be reversed as an abuse of discretion.
That has been appealed on that ground.
Exactly. Thank you, Your Honors, and ask the court to affirm the constitutionality of the statute.
Thank you, Mr. Snow.